Okay, everyone, updates on cases I've been following. The Don Lemon criminal case. It was a quiet week for Lemon and his co-defendants, except for one.
As you can see, all these pretend Christians, all these comfortable white people who are living lavish, comfortable lives while children are dragged into concentration camps. You're living real.
William Kelly, a.k.a. DaWokeFarmer. Now, last week, the magistrate judge granted his motion in part to modify his release conditions. Now, his only release condition is he has to report to pretrial services and submit to a mental health assessment and stay away from City's church like all the rest of the defendants. But the government appealed. The government wants all of his release conditions reinstated, including the prohibition on being allowed to carry a firearm. Now, the government says he's a danger to the community. But the federal public defender says, well, you don't know that. You've never presented evidence that Mr. Kelly is a danger. But there's a good reason why the government hasn't come forward with evidence of the defendant's danger at a hearing. Okay, let's look at these docket entries. The government requested a detention hearing for Kelly in January at his initial appearance. The magistrate judge denied the request and set a bunch of release conditions instead that defendant Kelly now finds too restrictive. Now, my view on this is he's not in jail, okay? The government wanted a detention hearing. The magistrate judge denied the request, so the argument by the defender isn't all that persuasive and could even place his client at risk of detention if the evidence is presented at a hearing, which is what the government wants. Now, Kelly could be detained pending trial if it comes to that. So, now, why did the defender take this risk and double dare the U.S. Attorney to file exhibits showing that Kelly is a danger to the community? Now, you know the answer already. The defender wants a preview of the government's case against his client, and he thinks there isn't much risk that his client would be detained pending trial anyway. Now, theoretically, he could be, but probably not. And the defender probably is a bit unsettled because last week the government revealed that Kelly is the defendant churchgoers feared the most. The government disclosed that publicly last week in a filing. But for those of us who've watched the video footage, it was no surprise. Now, next case, search warrant executed on the residence of Washington Post reporter Hannah Natanson. Now, she was one of apparently numerous journalists who received classified materials from an indicted leaker at the Pentagon. Aurelio Perez-Lugones. He's been indicted. Now, he accessed classified information, copied and pasted it into Word documents, removed the classified headers, and fed the information to journalists. A crazy person, okay? Now, it seems that he hated the Venezuela op to capture Maduro, to stymie the drug trade and the human trafficking trade, and to get the oil flowing again to light the paths of billions across the world. Now, he was opposed to all that. So what happens to all of the classified information that the feds seized from Hannah Natanson's residence? Well, the search warrant said they're only looking for evidence relevant to perez-lugones. Now, a filter team from DOJ would sift through the classified material, remove all traces from Hannah Natanson's devices, then return the devices to her, unless there's a reason not to do that. Now, the magistrate judge ruled against DOJ and said he and his staff will go through the material to sift out the classified material and return it to the government. Now, the DOJ strongly objected to that procedure. The DOJ said, "With all due respect, magistrate judge, that's boneheaded." So the DOJ says to the magistrate judge, first of all, you have no expertise or authority to identify classified information. You wouldn't even recognize it. You're not designated as an original classification authority under Executive Order 13526, Section 1.3, subsection A, and cannot be presumed to identify classified material. Now, you have no access to original classification authorities who could determine whether the materials contained unmarked classified material or national national defense information, especially where, as here, the classified headers have been removed by an indicted leaker, and snippets of conversations between Perez-Lugones and the reporter could contain classified information which you wouldn't recognize, Magistrate Judge. Now, you say you'll return the devices to the Washington Post after your review? Well, you could be turning over classified material which belongs to the government. Now, in my view, the government should win on this issue. The magistrate judge should allow the DOJ's filter team to do what they're uniquely trained to do. Now, the Washington Post objected, of course. They say that there could be privileged information on the devices, and they say that the filter team would be making privileged determinations for an adverse party. No, that's not what would happen. The filter team is separate from the prosecution team at DOJ. Law firms do this type of thing all the time. It used to be called a Chinese wall, but the ABA, American Bar Association, is moving away from that parlance and calls it an ethical wall or organizational barrier to prevent information being shared within organizations where conflicts of interest would make it ethically an issue. So the ABA doesn't have a problem with the use of organizational barriers, and the Washington Post doesn't have much recourse here. Now, especially given that the Washington Post's own conduct placed it in this position. And if the Post feels that its right to maintain the confidentiality of its sources is compromised, it can file a civil action against the government after the fact. Now here, the Washington Post is asking for a remedy before there's been a violation. The court hasn't found a violation of the newspaper's rights yet. Now, the only thing the court did is approve a search warrant on the reporter's residence after the government showed probable cause that the Espionage Act was violated and obtained an indictment against the alleged leaker. Now, this is a textbook illustration of the principle that if you lie down with dogs, you get up with fleas. Now, I don't say that to minimize the angst that the Washington Post and its reporters might go through as a result of the search, which should be done by the DOJ's filter team. But the media should be aware that when they're dealing with a Pentagon employee who's feeding them information that hasn't been made public by the Pentagon itself, they probably should suspect that the information is a classified leak. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.